Hello, Gerry. How are you doing today?
I'm very well, thank you.
Good to hear. Could you please help us in learning more about mediation?
I certainly can do my best.
I have just some questions.
Okay.
So, the first one, could you please introduce yourself?
Sure. My name is Gerry DeSimone. I'm an attorney in the state of California of the United States. I've practiced law for 39 years. After practicing law for that long and trying many cases, mostly jury trials, my wife decided that it was enough, and I agreed to come to Pepperdine University and assist as an instructor in trial advocacy. While I was here, I began taking classes in mediation. I had sat as a mediator before this, and I had represented parties in mediation for many years before that.
Okay. Would you explain mediation in plain English?
Sure. There's what we call alternative dispute resolution, and this is basically the alternative to litigation, taking matters outside the court. Now, obviously, we have arbitration, and I know that, especially on the international level, people are pretty familiar with arbitration. Mediation is more informal. It's not controlled by rules of evidence. It is basically an informal procedure where parties get together with the assistance of a mediator, and the mediator tries to facilitate or assist the parties in getting the matter resolved, bringing it to a agreement, a settlement, so that it can be taken out of the litigation system.
Thank you. Can you walk us through the process of mediation?
Sure, there's lots of types of mediation, but let's talk about a litigated case to start with. So a lawsuit has been filed, and let's just assume for purposes of this that there is one plaintiff and there is one defendant. Now, you can always have many plaintiffs, you can have many defendants, but for simplicity, let's assume that. After the matter has been in litigation for a while, the parties decide it's in the best interest of them, the lawyers, and many other people. It could be for economic reasons, could be for health reasons, could be because recently, obviously, we had a pandemic, and that caused a lot of congestion in the court system, which delayed litigation. So the parties decide they're going to submit the matter to mediation. They will hire a mediator. In many countries, there are mediation services such as JAMS, Judicate West, ARC, ADR, and you would contact them. You would select a mediator, and then there would be a meeting where you would get together. Mediations can be done all over the world, though, because in today's day and age, many of them are done via Zoom. So, for example, if I were to sit as a mediator and I had a party in Kazakhstan and another party in London, I could be in Malibu, California, where we are today doing this, and still conduct a mediation because we could do it remotely. We would go over the various aspects. It can be done in a joint session where we're all together, or it can be done in a caucus where we separate, which is my preference. So that's how we would handle that.
Thank you. What types of disputes are suitable for mediation?
Candidly, almost every dispute is suitable for mediation. I'm not a family law attorney, but family law is an area that there is a lot of mediation that gets done. So, for example, a couple are no longer suitable to be married. They decide they want to break up, and they have children, and they have support issues, and that can be addressed through mediation. Businesses have a dispute. Let's say it's a supply contract, and the company that's supposed to receive whatever the supply is feels that the product's not properly made. The supply company feels that it's not been paid for. They can bring that dispute to a mediation. There's been an auto accident and somebody's been injured. That can go to mediation. A product liability, an employment dispute. Virtually anything that is suitable for litigation is suitable for mediation.
Thank you. Is the outcome of mediation legally binding?
Well, answer is yes and no, and let me explain what I mean by that. A mediation is an agreement where you come together to try and resolve a dispute. In that situation, if you come to an agreement, in most jurisdictions, and we're in California, so I'll just use the example in California, we have a code provision. In California, it's the Code of Civil Procedure, specifically section 664.6. And if the parties come to an agreement and they sign the agreement, and one party does not live up to their bargain in the agreement, that document can go to court, and the court will convert the agreement to a judgment so it's legally binding and can be enforced.
Thank you. What happens after a successful mediation?
Well, hopefully, you said successful, so the parties have come to an agreement. and let's assume that party A agrees to pay party B X dollars, whatever that X is. Once that is paid, usually the lawsuit is dismissed and the parties go their own way, and it's simply done. Sometimes in mediation, it requires years of payments or years of obligations, and it could continue to last, but presuming that they are living by the terms of the agreement, for the most part, you're done with at least the conflict at that point in time.
Thank you. How can we encourage individuals and businesses to use mediation?
Well, let me first go back to the fact that I'm a trial lawyer. So for a long, long time, my reaction was, let's go to court. Let's go to the courtroom. I think I had a number of clients who saved me from me, and they would sit there and talk about the expense of this and let's try and settle it. Economics plays a big, big factor in why matters should go to mediation. People like me don't come for free. Lawyers are paid, and lawyers are paid well. So that plays a factor in. Litigation costs, such as the filing fees, the deposition costs, expert witness fees, are very, very expensive. So those are things that really should be addressed with a client before time to say, is this matter really suitable for mediation right now before we start incurring all of these costs? Likewise, on top of it, it also takes out any of the risk. If you have a lawsuit, there is some type of exposure. You'll have a situation where you could get a judgment against you for X dollars, or if you lose, there could be costs or attorney's fees that you might have to pay. It takes that element out.
Thank you. Can you describe one of your most memorable mediation cases without disclosing names?
Sure. I've had so many. I will, let me tell you one that I had in the past 2 years where I sat as the mediator. There was a woman who went to a coffee shop to meet with friends. They sat on the patio, and while they were having coffee and talking about certain issues, it got very windy. And the wind lifted the umbrella out of the umbrella stand. Now the umbrella stand, because this is a large coffee chain, the umbrella stand was supposed to be in, and it was supposed to be latched in a certain way. And apparently the latch was not working. The umbrella lifted out, and the pole hit the woman in the head, and ultimately she suffered a brain injury. And I was asked to be the mediator in that case.
Thank you. What obstacles have you encountered while mediating disputes, and how did you handle them?
Sure. In fact, let me go back to the case I just told you about. We'll talk about some obstacles. So that case, there obviously was a tremendous disparity in views on that case. The coffee company felt that they were not responsible, they could not anticipate the wind, and they questioned whether or not the umbrella stand was really defective. Part of their problem was that if it wasn't defective, there are a lot of people out there, how do they know somebody didn't play with the latch? So their position was that they owed nothing. In turn, the people who represented the injured party felt this is a significant injury. So we started off where people were very polarized to start with. We started the mediation because it was ordered into mediation by the court. So we started with a session of mediation, and it was not successful at all. But I did say, if you want to come back for another session, why don't you let me know and we'll reschedule that. About 3 months later, they came back, and the coffee company was now of the opinion that, yeah, there probably was a problem with the umbrella stand, but they were now questioning whether or not the woman was really that seriously injured. So in that situation, obviously, the injured woman felt that they were questioning her integrity, that she was making a claim that really wasn't accurate. And that created a lot of polarization there. Sadly, we didn't get it settled again. And then it was ready to go to trial. It was supposed to go to trial on February 14th, which would have been Valentine's Day, about a week, I think it's a week ago yesterday. And about 2 weeks before trial, it once again went to mediation before me, and we were able to get it settled. The problem was that it took so long when we got to trial that the expense and the economics of it were really gone. We could have saved that earlier. But one of the problems with mediation is when there really is a dispute as to what happened or is there something wrong with the product, sometimes a lot of discovery has to be done to figure that out, because companies, defendants, people who are being sued don't want to pay money if in fact they don't owe money. So sometimes they have to figure that out as well.
Thank you. And in your opinion, how can the mediation process be improved?
Well, having spent time at Pepperdine Strauss Institute of Dispute Resolution, I can tell you that I've studied mediation around the world. I think a lot of it is getting parties to know about mediation, to educate parties about mediation, and to motivate them. So, for example, the Italian system requires you to opt out of mediation. You're required to go to mediation unless you opt out. And then there are certain issues if you opt out as to what you will need to do and whatnot. Other European countries have where you opt in. So you have to be interested, and then you opt in and you choose to go to mediation. They don't seem to be as successful. After the pandemic, the Los Angeles County Superior Court started a system called Resolve LA. And it is a case where the court will not give you a courtroom to start your trial unless you go to mediation. It is a program that is very favorable economically because the mediators actually volunteer their time, and they give 3 hours for a mediation session. The matters are usually set relatively close to trial, so people now have an incentive. They realize we have to go to trial, there's more expense there, and likewise, we could win or we could lose, so it gets ordered. I think that human nature is to do nothing unless you're compelled to do something, and I think court-ordered arbitration or opt-out arbitrations encourage people.
Thank you, Gerry, for your answers and your time.
No problem. It's my pleasure.
Thank you.